If you are found guilty at trial, or you plead guilty or no contest to a criminal charge and you do not have a negotiated sentence, you will be scheduled for a sentencing hearing. Today we're going to take you out of the crowded courtroom and walk you through a typical sentencing hearing. The first thing we need to distinguish between is a felony sentencing hearing and a misdemeanor sentencing hearing. Felonies come with sentencing guidelines. If you plead to or are found guilty of a felony offense, the state and your attorney will calculate your guidelines. Your guidelines take into consideration the offense, whether the victim was injured and how bad, your criminal history, and other factors to determine the minimum sentence the judge should sentence you to. Many nonviolent felony offenses will call for a non-prison minimum guideline sentence, which allows the judge to sentence you anywhere from the time served that you already have to probation, all the way up to the maximum sentence allowed by law. Make sure to go over your guidelines with your attorney. The judge does have authority in certain situations to go below those guidelines, but it's important that your attorney be familiar with your particular judge and know when and how often that judge deviates from guideline sentences. For misdemeanors, there are no guidelines. The judge is free to sentence you anywhere from time served or probation, or all the way up to the statutory maximum sentence allowed by law. So what happens at a sentencing hearing? Both the prosecutor and you, through your attorney, can put on evidence in aggravation or in mitigation. The prosecutor may put on aggravating evidence to try to convince the judge to give you a harsher sentence, but usually the prosecutor will just argue the aggravating facts in the case. Some aggravating facts may be that you were abusive to law enforcement, you have a long prior criminal history, some egregious conduct, injury to a victim, amount of loss to a victim, and any other fact that may make this case worse than another. Your attorney will put on mitigating facts like your prior service to the community or military service or your lack of record, your upbringing, awards you've received, cooperation, and any other fact that tends to show that this case isn't quite as bad as some others. You can call witnesses to testify for you. They can tell the judge what a good person you are, what your plans are for the future, and whatever else your attorney thinks the judge might want to hear before sentencing you that might help. You can present exhibits like certificates or awards or a GED that you've earned while the case was pending, or anything else that might help in your case. Your attorney can draft and file a sentencing memorandum, asking for a specific sentence and laying out the reasons why the judge should give you that sentence. And you can talk to the judge yourself. Once both sides have presented everything they want to present, the judge will render a sentence. You can appeal the sentence, but the judge is given great discretion in sentencing, and those appeals rarely succeed. Another thing to consider is that it is really important to make sure that your case stands out from the crowd. To you, this may be the most important thing in your life. To the judge, it's just one more hearing of many. Your case is a grain of sand on the beach. You have to figure out how to stand out, because judges are human too, and they tend to get into a rhythm and simply sentence people similarly. You want to show the judge how you in your case are different from all the others, and why you deserve to be treated better. Hopefully your attorney can do that for you.